brothers and sisters, and friends, and I see some enemies. In fact, I think we'd be fooling ourselves if we had an audience this large and didn't realize that there were some enemies present.
What about this question? Put a little setup and just say, hey, you know, I live here in this place, and they're accusing me of, you know, breaking this law. Do you think that this law applies to me? You know, do you believe that this law applies to me? Aren't they going to say yes to that?
You're asking them for their default judgment, I guess. Now, but how do you convince anybody that shows a bias? Because all they have to do is instruct them. As soon as they instruct them, well, you know, you need to show that every element's proven. See, you know, to believe somebody and then believe it's been proven are two different things. So they can sidestep it, you know.
Well, it's a presumption.
Yeah, but all they got to do is be instructed to not have that presumption. You see, they have it at that moment, but all they have to do is be told, well, okay, just don't have that presumption. We're good. You see?
Or maybe something like something about the evidence, like what would it, you know, what evidence you need, you know, what evidence would it take to convince you that this law applies to me or whatever? I don't know.
There you go. That's pretty good. That's pretty good. One of the things that the court does to jurors is they switch the question on them. I'll explain. So in the beginning, the question is, do you believe he's guilty? Okay. With all the ethical implications that has. That's a moral judgment, right? Okay. And at the end, they swap that question out to say, do you believe that the prosecutor showed that he did what he's accused of doing? Now, they're related questions, and they're easily confused, but they're slightly different. One of them is, do you believe that factually this happened, right? And the other one is, do you believe that these facts happened and constitute a wrongdoing, guilt? Okay, it's not, do you believe this occurred? It's, do you believe he's guilty? So at the beginning, and in the penumbra, you know, in the grand scheme of things, they try to make it seem like the question is, do you believe he's guilty? And that's actually what they want them to answer. The answer that they want is in the form of, if you believe he did these things, you need to say he's guilty. That's how you tell us that you believe he's done these things, that these events occurred. And the way that you say, I don't know if these events occurred, is by telling us he's not guilty.
Right.
And it's underhanded shell game. It's a swap out. So the jurors end up believing that the only way to communicate the idea, what they've been asked about is, do you believe these events occurred as described by the prosecutor, is to say he's thus guilty. He's guilty. They don't understand the ethical component of saying he's guilty. Because he's guilty not only means that these events occurred, or even that they didn't. They mean that you believe that somebody has guilt. Now, guilt is not just events occurred. Guilt is an ethical construct, right?
Yes.
It's not that they. Yeah, it's not. It's not some legal. You're not being asked about the legality of something. They're asking very specifically, do you believe he, you know, what is your verdict? What is your judgment? Is he guilty? But they've swapped the question out on people. So in a voir dire, you would, obviously somebody who is not mentally capable of separating those two questions should be dismissed for their mental incompetence in dealing with the issue at hand. So a question designed around somebody's ability to differentiate between guilt in an ethical context, what guilt means, and that that you believe that the events occurred as the prosecutor describes. They're trying to substitute people's conscience with the judge's order. And they say it all the time. That you'll take your legal instruction from the judge. He's here to decide the law. You're merely here to decide the facts. But that's not what they're asked to, the verdict. The verdict doesn't say, we find that these facts occurred. The verdict says we find him guilty. And that's a dirty fucking trick. You see, they purport to take away somebody's ethical judgment, but still put the words in their mouth as if they made the ethical judgment. So questions designed around understanding what the difference is between saying that somebody physically did something and saying that he is thus guilty. Do you understand who makes that judgment and what it means for you to proclaim that someone's guilty while you're proclaiming that you believe I'm guilty, that the accused is guilty, versus you believing that the facts are true and that the judge would feel that the accused is guilty. Because that's what they do. Yeah, Mom.
Yeah.
Because the judge tells them, here's the law, here's the ethics of the situation. They're very careful not to say ethics. They're saying law. And talking about guilt and innocence in a law context and mixing up factual determinism. So questions that really dig at that, they'll probably disallow and could be denied voir dire, which is a due process violation, by the way.
I'm sorry, could you repeat what that due process violation was?
Denial of voir dire of the juror in this case. Witness would be another one too. So one of the goals, of course, is to get them to stop you from asking questions that are valid, responsible, relevant questions. And if you're asking about that sort of thing, they're going to disallow it. They're going to stop you from asking it. If you're asking about things like if they know who the judge works for. Now they, again, they love convincing us to give up our rights, right? These are fighting rights, as they say. If, as sadly was the case in James events, they ask you for a list of questions for their approval or for them to ask the jury. They're asking you to suggest questions for them to ask. And I'm not a big fan of that. I have my own questions to ask. They can ask whatever questions they like, but I'll have my own questions as well. And they want to imply and get you to cooperate with the idea that they should be asking the questions. The voir dire questions are the judge to do. And it's like, no, I'm sorry. I'm not going to be denied voir dire just based upon the exchange. The judge will cover it for me, Oh, don't worry. The judge will do a good job. Don't you think? I'm sure the judge will do a great job of doing the voir dire. You see, there wouldn't be such a thing as a denial of voir dire if it was good enough that the judge do it. You're giving him the voir dire question in advance so that he can construct a question that covers the same topic in a worse way and sabotages your own question, makes it look stupid, And so when they ask you for the list of questions, just to clarify, well, are you intending to deny me voir dire, or are you looking for suggestions of questions you should be asking? If you want a list of questions, Judge, that you should ask them, I'll give you a list. You want some suggestions? Dear juror, do you know that I'm paid by the same person as the prosecutor is? I don't think he'll ask him, but I'll have my own list for my own self, and I'll make it clear that I do. It's like, if you want suggestions for me to help you come up with questions that you should ask, here's some questions that would make this very, very fair. And by the way, I have my own list that I intend to ask. Would you like me to ask mine first or last? But the deal is, of course, just like with any of these, with any of this, for instance, I was arguing with EL earlier, arguing with these people to get these confessions Yes, I know they don't cooperate with these things. Duh, I'm very aware that clerks do not cooperate with doing their job. It was stupid of him to say that, of course, that argue with me about that. But he was missing my point in that you've got to construct things to where silence is damning, to where ignoring you is damning. And just because you can't imagine doing it means you should probably have a little bit more conversations about how to do it, not just proclaim that it can't be done. Bring up the point and say you've had difficulty, but that's one of the big rampant problems in the group here is a couple folks who say, yeah, I tried that and it didn't work. It's like, really? Really? You believe you gave it the best try it could have? And furthermore, that just because it didn't work in one instance means it can't ever work? But that's the point is the idea is like, hey, getting that, treating that clerk just like you treat the judge, I mean, yeah, it's I guess people keep saying it's like, well, it's easier just to step on and move on to the next stage. It's like, well, they're all tough. If you think that the clerk is tough, the judge is going to be tougher. If you think the judge is tough, that appellate court judge is going to be even tougher. It gets harder and harder, and I'm sorry if even step one seems impossible. That's kind of the boat we're in, But I'm preaching to the choir here. I mean, we've all faced horrible judges. Is that nobody's had a judge go, oh my God, I've never looked at it like that before right off the bat, and be like, I'm sorry, can I offer you a ride home? buy you lunch while you're here? We were absolutely horrible to you. God. I worked with this guy for years, and I presumed he'd have this. Every judge is going to consider his right to nix a question about any question that's not relevant. They can nix it, which is why extremely embarrassing and relevant questions are really important there. And when they do stop, it's like, I'm sorry, that is a relevant question to a juror. It's a relevant voir dire question to a juror. Well, what possible excuse would you have to deny me the right to voir dire in this instance? No idea how they'd answer. Never seen it done. I've heard stories about people saying, one of the issues in contention is that I'm a subject of the plaintiff's state. That's one of the issues in contention. So, these people, in order to be my peers, if I am correct, they cannot be members of the body politic. And if the prosecutor's correct, they would need to be members of the body politic. So as of right now, what is this court presuming? Is it presuming that I am and thus choosing jurors that are members of the body politic? Or is it going to go number safe and err on the side of justice and find jurors who are not members of the body politic?